I was wondering if you could explain to us. I always want to kind of like know what to expect when I get into something. So like I think most of us, not most of us, but if you want to observe a court proceeding, you can just walk into court, obviously. But now arbitration, because it is private, nobody's really allowed to walk into an arbitration and see what it's like. So could you explain to me a little bit about what an arbitration hearing is actually like? Like, is it like just an office that people attend, and then you got the arbitrator sitting in the middle, like just details?
Sure. Well, okay. So remember what I was saying, though, about how you can build a process that is
Right.
custom fit to the problem and the
Mm-hmm.
legal issues, of the parties, right? Well, I have worked with people to develop a process that essentially amounts to the lawyers or the parties giving me written arguments where there is no hearing. We don't need to be in the same place, and I can make a decision based on the arguments and the law that people have provided. But that is cheap, it's fast, and it's obviously the shortest, most compressed process there is.
Yes.
Sometimes, though, I might work with people and develop a process where we agree that all of the people's evidence and direct will be given by affidavit,
Right.
and that there will be a limited opportunity to conduct cross-examinations to test the truth of what they've said in their affidavit. But of course, at the other end of the spectrum, you can have a process that looks just like court, that is just as complicated, has just as many bells and whistles, and just as many features, right? So in any hearing where I am hearing oral evidence or I am hearing oral argument, in general, prior to the coronavirus, we'd be in a boardroom with everybody around the table, and I sit at the head of the table so that I can see everybody. And
Mm-hmm.
usually the parties are right next to me and their lawyers are next down the table. And that's it. There's nobody else in the room. And when witnesses other than the parties are called to give evidence, they're waiting outside, and they would come into the boardroom and they would take a seat at the table, and I would ask them to swear or affirm that what they're going to say is true. And then it can look just like a courtroom, right? Except it's occurring in the less formal context of someone's boardroom, and there's no court clerk and there's no sheriff, right? So it's the process looks just like a court process because the lawyers or the parties are examining and cross-examining the witnesses. They're presenting oral evidence, and in the meantime, I'm recording the proceeding, and it looks just like a court process, but it's happening in a boardroom, and we have a lot more flexibility. So we can start at 7 o'clock in the morning and go till 7 o'clock at night if that's what people want, rather than the 4.5 hours that are usually available in a court day. We can have lunch brought in. I usually have bowls of snacks and beverages sort of hanging around, so that all of your needs are taken care of.
Yeah.
But so that's what it looks like.
Can you opt to have a court reporter type person sit there and record the proceeding so that you could ask for a transcript later? Is that possible?
Well, absolutely. Yeah.
Okay. So you're allowed.
Really, in arbitration, anything is possible, right?
Okay.
And I mean, to give you an idea about how flexible this process is, right? The only thing that the arbitrator must do
Mm-hmm.
is the arbitrator has to be and appear to be unbiased, and the arbitrator has to provide a basic level of fundamental justice. That's it, right? So essentially, it's being unbiased, and it's ensuring that each party has received due process. But there's really not much more required than that. Whatever other requirements that may be mandatory are a function of the arbitration legislation of each province and territory, right? And so the Arbitration Act in British Columbia is different than the Arbitration Act in Alberta, which is different than the Arbitration Act in Ontario, right? Mm-hmm. And so some provinces have arbitration acts that require decisions to be in writing. Other provinces make that discretionary. Some provinces have circumstances where there must be a written arbitration agreement. Other provinces don't require that. And so really, like, the things that are absolutely mandatory in the process are fairly small, right? And there is just so much flexibility about what you can do. And so if somebody wants to record the proceeding, great, that's fine. I mean, I make a recording so for my own purposes, so that I can be sure that I understand what someone's evidence was, right? But I don't make that available to the parties. It's just for my purpose. And when I'm finished writing my award, I erase it, right? But if you want to have a court clerk come in, or you want to record it in some other way, you're welcome to do that, but you're going to have to pay for it.
I totally did not know that. I have no idea that it could be that flexible.
Oh, yeah.